Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our 2-weekly call that we do on our bridge. The call is held every week, once a week on LinkedIn, 1 week on LinkedIn, the other week on our bridge where you are today. Now, the format for today is that I have to answer first the posted questions. Then if I have time, I might answer new questions. Today, I'm pretty sure I will not have time. I usually tell people in the team to cut off the questions at 10 because I can answer 10 questions that are posted and then take new questions. I have 18 questions already, so I'm pretty sure I won't have time for new questions. You still want to stick around your call, but it's unlikely I'll get to new questions. Let me go over the questions that are marked as frequently asked questions. I saw some of the questions were things I get asked again and again. So we saved them to our website, immigration.com, under the frequently asked questions session. First question is about AC-21 Supplement J and salary increase. So when you use AC-21 portability, that means your I-140 is approved, your 485 has been pending 180 days, and you go to another job, there are some requirements. First of all, when it is after 180 days of 485 pendency I-140 approval, you no longer have to do the green card again. You can carry the same green card, which is called porting. The requirement is the new job and the labor certification PERM job should be same or similar. Same or similar. So that's where this idea of salary increase comes in. Can I get paid more in the new job? Can I get paid less in the new job? So let's see what the exact questions are. I'll try to address all of them for you. My AOS is pending 180 days plus. So which is less risky? Filing AC-21 right after 180 days are complete, leaving the current employer right after getting the green card. I think option 1, which is after 180 days, you can change jobs. Number 2 question, salary increase. If I'm getting a salary increase of twice almost, which is 50% up from my current job, is that an issue? Usually no. Okay, because the amount of salary depends so much on so many different things. When did you start the PERM? If your PERM was started 6 years ago, of course you're going to get a salary raise. Or if there is a promotion in the job, let's say you're going from software engineer, which was your PERM job, to delivery manager or even CTO, they are considered to be same or similar if they are promotion. So salary is not the key issue. The key issue we have is, are the two jobs same or similar? Salary is just one of the things we look at. Okay. What should I consider to keep in mind when changing from A to B when filing supplement J? Same or similar jobs. Your lawyers should definitely review the two jobs and give you an opinion whether they are same or similar. I'll give you one small example, which is my own opinion. Okay, let's say you're a database administrator, okay, and you were an Oracle DBA. Now you have become a SAP HANA DBA, but your title is still DBA, your job is still DBA. Are these considered to be same or similar? I think so. Just because the technology changed, the basic nature of your job did not change, which is database administration, right? So that's what same or similar means. It also means promotions are okay. If you go from software developer to CTO or manager, that's perfectly okay. But if you go from software developer to, I don't know, head of HR, VP HR, probably not okay. All right. Is it advisable and recommended that we stay with our employer for 6 months after getting a green card? There is no such rule. This is all a made up situation. You just look at our frequently asked questions on immigration.com. I've discussed this issue many times. There is no such rule. The rule, if there is one, is this. On the date you filed the I-485, you had no intention to leave the employer. On the date you went for the interview, if there is an interview, you had no intention to leave the employer. On the date your green card got approved, you had no intention to leave the employer. So 3 junctures: when you file, when you interview, and when you get approved. No intention. But 3 days later, you get a great job offer. Satya Narala calls you and says, I'm resigning, why don't you take over my job? Do it. Why? Because on those 3 important dates, you had no intention to leave. If this issue comes up under naturalization proceedings, I think you have a very good case. Okay, so if you want to be even more secure, well, then stay as long as you can, 6 months, 8 months, 10 months, there's no limit. But personally, I don't think there is any risk in leaving the employer if the situation changes. I had an appointment today, a consultation, where somebody who had worked with an employer for 5 years had no intention to leave when they filed the 485, no intention to leave when they got the 485 approval. Month and a half later, the employer said, well, because of performance issues, we are letting you go. Okay. Now, I have an email that shows very clearly the performance issues did not arise until after the green card was approved. So he has a very safe case, even though he got laid off about a month and a half after getting his green card approval. I'm not worried about his case at all. This is nothing he did. It's just the way it worked out. Okay. So then he says, next question is, if I'm filing AC-21 J supplement versus moving right after the green card, are both things considered the same? No. I think in these cases, supplement J is better. Okay. I certainly think, because you already have made up your mind you want to leave. So instead of trying to defend your decision to leave after getting the green card, and that would involve some lying because you've already made up your mind to leave. Okay. So I think supplement J and moving before your green card is approved is much better, in my opinion. Folks, I want to remind everyone, I won't have time for new questions today. I have enough posted questions that will take up all our time. Okay. If you have any follow-up question to what I just discussed about AC-21, press *5. No more new questions, just follow-ups. If you have a follow-up, press *5. I'm going to lock the conference because I have enough people here. 1 second.
The conference is now locked.
Okay, let's see. We have one question from Ohio. Ohio, go ahead, please. I can hear you. Ohio.
Hello, sir. Question related to liquidated damages.
Okay, sure that's nothing to do with what I discussed. Sorry, I can't take that question. Yeah, I'd asked you. It has to be something related to what we are talking about. Okay. So next question is also frequently asked question, EB3 PERM green card application. Implications of applying for a future promoted role. Now guys, this is an important point. Remember this. Let's say you were born in India, okay, where the green card is taking 10 years. And you are working right now as a software developer. When you apply for your PERM, you will get a green card in 10 years. Should you apply for software engineer's job or a job that you think you will have in 7, 8, 9 years, 10 years? So I think you should apply for a future job. By the time you get your green card, it will be so many years would have passed that if you apply for software developer, you would definitely have overshot that job. So typically, if I'm doing a PERM application, I often ask what would be the job offered in about 8 or 10 years. Okay. And if they say it's going to be a project manager, I suggest that we do a PERM job or PERM filing for a project manager. Okay. So that's normally what we do. So the questions here are, I-485 filed for EB3 rest of the world category. I'm not in the PERM sponsored role. My green card was prepared for future job. So he's not or she is not India born. So they have a different category. My AOS is filed, but I still don't have that role. I'm not promoted yet. What are the issues or risks? So first of all, remember, you don't have to be promoted when you file the 485. You should be promoted within a reasonable period of time after you get the approval. They can always do it before, but they should be doing it within a reasonable time, maybe 4 or 5 months after you get your green card approval. Okay? If my green card is approved, I'm not in that role, what are the consequences? No consequences. I just told you, you have to have that role after the green card is approved. Is it necessary for me to have that future role? Okay. Well, that's another interesting question. If the employer honestly thought they'll be able to give you that job, and they filed the case, but after the green card is approved, the company has some issues, they are not able to give you that job, I think you'll still keep your green card because everybody was acting in good faith. Things just didn't work out. Okay. So I don't think it's going to be a big problem. I try to avoid this situation because there is controversy here. But if push comes to shove and you get stuck in this situation, I think you'll be okay. That covers all the question. Press *5 if you have a follow-up question. No new questions. Today I'm not going to have time for new questions, I don't think. Okay? Only posted questions and follow-up questions. No follow-ups today? Not on this one? All right. Let's see if there's another frequently. Here's another one. H4 EAD or otherwise and remote work for Indian company. I have an H4 EAD. Can I take up a job on Indian payroll? Absolutely. If you did not have an EAD, I would be hesitant to say yes. But if you have an EAD, working on the US soil for a company outside USA is perfectly legal. Just remember one thing, figure out the tax angle. You probably will have to pay taxes in USA. I'm not a tax lawyer or a CPA, so check with an accountant. *5, if you have a follow-up question, press *5. All right, no question. Another follow-up question, another frequently asked question. Staying in and working from home country with long pending I-485. And this is an interesting situation, and I do get asked this a lot. Hold on one second, let me grab some water. So the question is, I have a 485 pending. Let me look at 2 or 3 different angles of this question. I have a 485 pending. I have my advance parole for 5 years. I have my EAD for 5 years. Can I go chill out in India for the next couple of years, 3 years, 4 years? Well, there's nothing stopping you from doing it. Okay. But the employer who applied for you should have some continuity in the job unless you have done a supplement J under AC21. That means changed employers to same or similar job. So the difficulty here is this. Green card is based upon an available job, whether it is through the same employer or through a same or similar job with another employer, right? So if you were going with the same employer and you're working from India for that employer, I don't see any problem. Okay. Excuse me. But if you quit that job, that raises the question, do you have a green card job anymore? Now, what if you get a job offer from another company and you start working for them? I think that's okay too. Just file your supplement J. That's the safe thing to do. Because when you try to enter the US again, the CBP is going to look at your paperwork and say, you've been gone for 2 years. You definitely don't have a job in the US anymore. But then you say, no, I have a job. I've been working with the same employer, or I've been working with a different employer through whom I have filed the supplement J. So there's a continuity of a job offer. Okay, you should be okay. And if your green card gets approved while you're outside USA, you can still travel back using your advance parole. And then at the airport, US airport, you can show them your approval notice. They will let you enter as a green card holder. Okay. So that's how it would work. Now let's see. Can I go back to India, work for the same employer 2-3 years, then return? Yep. Can I convert my case to consular processing? Yes, you can. But there should be a continuity of job even there. Okay, no problem. Then there was a similar question asked by another person. So I combined these two. Can I travel back to USA after 3 years? Sure. I already discussed the issues. Any impact on my pending I-485 till my dates become current? Yeah, as long as your advance parole is valid. Yeah, I discussed all these issues already. So I kind of preempted the questions. Anybody has a follow-up question? Press *5. Any follow-up question? Press *5. Okay. Let's see. This is area code 412, which is Pennsylvania. Yeah, Pennsylvania. Go ahead, please.
Yeah, hi. So you said like I need to have a job during the entire time till my green card becomes current.
Well, if you are going to come back to US for the sponsoring employer who first did your green card, you should have a job with them. Okay, the same job. But if you are going to change jobs, you should get a supplement J filed. What if you're in between jobs? Let's say for 6 months you don't have a job. I would suggest get a US job as quickly as possible, because it creates a continuity of your desire to work in the US and you have a job in the US. This could become relevant when you enter the US. This could become relevant.
So if I'm trying to say that...
yeah, go ahead.
Sorry.
I was just trying to, let me finish the
If I'm
sentence.
saying
Let me finish my sentence.
Okay.
I was saying that this continuity of the job could become relevant when you try to enter the US after a long time. Okay. Theoretically, there's nothing wrong with it. But as a practical matter, the government wants to know you're not playing games and you actually have a job in the US, which is a continuing job. Is it a requirement of the law? No, it's a requirement of common sense. Go ahead. You were saying something.
Okay. So you're saying like, let's say if I stay in India for 2 or 3 years without a job, and if I'm coming back on AP without a job or without working in US for any employer, then I can be stopped.
There can be, your intention can be questioned. See, what happens is when you are outside the US trying to come in, your rights are a lot fewer than if you're already in the US. You have more rights in the US and less rights when you're outside US. Okay.
So having an AP means, so if you are pending 485 and you have EAD AP, then you should always have a job.
Yeah, it's pending 485 is not a guarantee of the survival of your right to return to the US. Okay. Pending 485 is also does not assure the government that you have an ongoing job. It's not a requirement of the law, but it's a requirement of common sense, in my opinion. Now, if I got desperate, so let's say the tech hiring environment is bad, I'm a QA guy, I went to India, couldn't find a job, stayed out of a job for 2 years, then got a job offer, and now I'm returning and I have a job offer, I filed my supplement J, or I'm going to file my supplement J when I return to the US. Is that okay? Well, I think that's a better argument than trying to return without a job at all. Ideal situation is you have an ongoing job all the way through, whether with the same employer or another employer. Second best is you have a job offer. And the worst is when you don't have a job offer and you've been out a couple of years. Okay.
Okay. And one more question is, let's say if I go back to India, do I have to do consular processing before moving to India, or can I do it while I am in India?
I don't remember. It's the form I-824. Okay. Look it up. I don't know if you have to be in the US when you file it. I think you do. Okay.
Okay, and just last one is, does consular processing negate my EAD-AP cards? Like, does that take
Absolutely.
away those cards?
You
or-
don't get EAD-AP during consular processing. That's out.
Sorry. Thank you.
All right. Good luck. Let's go on to, I think our frequently asked questions are done. Yes. And I again remind people I have a lot of questions to answer. No way I'm going to get to new questions today. So let's go back and see what are our regular questions now. We did these frequently asked questions. I guess the first 4 were frequently asked. Then we start with the regular questions. Now, this is question number 6. Relocating with pending EB1 green card application and I-140 appeal. Okay. Oh, yeah, of course, you're very welcome. I have a question. Can petitioner relocate while 485 is pending and file AR11? Of course. The I-485 is associated with an EB1C and there's a pending appeal. So moving is not an issue. I don't see any problem with that. If you had a PERM-based case, we would have to look at your PERM application and see if movement is going to impact you. But for an EB1C, moving is not an issue. No problem at all. Okay. Star 5, if you have a follow-up question, please ask. If you have a follow-up question. Star 5. All right. Next question, number 7. US citizen returning with expired green card, SB1, SB2. Very difficult to get SB1 visas. If you have been outside for 1 year or more, getting an SB1 visa is really, 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 really difficult unless you have a very good reason. So we moved to India in 2013. Oh, that green card is long gone. Nope. I don't think you're going to be able to get it. You can try surrendering the green card and obtaining B2 visa. There's no guarantee, but you can certainly try. Can you sponsor her citizenship while you're in India? Only in very rare circumstances, if I remember correctly. I don't have all the details of the law, but if I remember correctly, it's only for expeditious naturalization you can apply while you're still outside. And expeditious requires like some kind of work for the US government or government contracting. There are a few, I don't remember, we've done a few of these cases, but I don't remember the exact details. For ordinary commercial employment, there is no such allowance. Okay. Press star 5. If you have a follow-up question, press star 5. All right. Next question, number 8. Canadian citizen with approved EB2 I-140, H-1B renewal and EB1 transfer. I had an H-1B visa and an approved I-140 EB2. Now I live in Canada and became a Canadian citizen. Can I still renew the same petition with my Canadian passport? Sure. I don't see why not. With the same organization or a different organization? That depends. If your I-140 was approved and stayed approved for 180 days and at least, well, let's just make it simple. If it was after January 17th, 2017, your I-140 approval and stayed approved for 180 days, you're good. You can get your H-1B extension even with the Canadian passport with any employer. And if I travel back to US on H-1B, can I apply for EB2 to EB1 category? Yes, you can. I don't see why not. If I travel back to US on an L1 visa, can I apply for green card under EB1 category with the same priority date? Yes, you can. Your priority date can be transferred from your EB2 to your EB1 case when it gets approved. Okay. No problem with that. We've done it many, many times. This is well documented, well tested. Star 5. If you have a follow-up question, press star 5, please. Okay. Question number 9. Using inactive H1 approval with STEM OPT and 2 employers. Okay. Approved inactive counselor H1 while on STEM OPT with 2 employers. I'm currently working with 2 employers full-time on STEM OPT. I had a counselor picked up H1 last year, but I want to switch my H1 to employer B now. How to safely transfer my approved inactive counselor? Well, this is a tricky one. Until 2023, towards the end of 2023, I had to change my mind because my feeling was once the H1B is approved, you're good to go. But I saw a ruling from the Administrative Appeals Office that kind of drew a different conclusion and a weird conclusion. So in an ideal world, I would want you to just get change of status to H1 right here with employer A. Once that is approved, then after a couple of pay periods, you could do a transfer. That would be the safest thing to do. You got it. Your item number 2 is actually saying that. You can just do it, change of status. I think that's good enough. Okay. So can you also do a concurrent H1B after your employer 1 H1B is approved? The answer is yes. Okay. Star 5. If you have a follow-up question, press star 5. This one is New Jersey. New Jersey, go ahead, please.
Sir, I have follow-up question regarding this. This is not my question, but I have doubt on this.
No worries.
That for transfer from STEAM OPT to H1B, inactive H1B, and how many consecutive pay stub we needed?
Actually,
generally,
even 1 pay stub should be enough. Okay, but there's no requirement for a certain time period. But the longer you can wait, the better off you probably are. Like I said, that decision from the AAO has made me doubt how the government reviews these cases. So if you can stay longer, that's great. If not, technically 1 pay period should be sufficient. Okay.
Right. And for an example, if employer has generated pay stub for the month of January, 2 pay stub, then they show as February month the employees took the vacation and they have a gap in 1 month, and again they generate a 1 pay stub for the 15 days. So is it still possible to transfer STEAM to H1?
See, I always get worried when people have these long gaps. Okay. So if you have 1 month gap, what is allowed and what is not allowed is this. What is allowed is if you have a genuine reason to take unpaid time off. Okay. What is not allowed is employer says, look, I don't have a project. Why don't you just take 1 month time off? So they can accommodate you for your need, but you cannot accommodate your employer because they don't have a project. That's illegal. Make sense?
Right.
Okay.
So there might be a consequences while transfer.
Yeah, I don't like that idea of a long gap.
Right. Because this happened with my wife because they have show as December 15 to January 30. They show that there is a vacation period because they don't have project.
This is fraud. Don't get involved with all that. Also, never get involved with the situation where the employer says, "Oh, I'll just make out the pay stub, but I won't pay you anything." That's illegal. That's fraud. Don't get involved with all that. Okay.
So should I complain regarding this to the employer, and what are the consequences
if you want to
transfer H1B or the?
Yeah, if you want to complain to the Wage and Hour Division of the U.S. Department of Labor, because as long as the employer has not revoked your H1B, they have to pay you. That's the law.
Right.
Okay.
Right.
So they should be paying.
And as a candidate, we are. Sorry, sir.
So if you file a complaint, that also is a good protection for your status because you are available, you were ready, the employer is playing games.
Right. So there is no consequences to the candidate, right, sir? If we
No,
have filed
if you
on
don't
time
get involved
regarding-
with any fraud of the employer, there is no consequence that I can think of. Okay?
Okay.
Good
Thank
luck. You're welcome. All right. Okay. Then let's go on to the question number 10. This one is H4 change of status plus EAD to H1B change of status. Impact on 6-year max out. Okay. Currently in a period of authorized stay based on pending H4 change of status plus EAD. New employer will file for H1B soon. If H1B is approved as a change of status and I begin working for new employer, will this time count towards my 6 years max? H1B is approved as a change of status. Yes, because you are on H1B status. Once H1B status is approved, you begin losing your H1B time. Once H4 change of status plus EAD has been approved, to kick off the new status and stop the 6-year clock, okay, I think what you're asking me is, once the H4 change of status is approved, does the H1B clock stop running? And the answer is yes, it stops running. Okay. *5, if you have a follow-up question, press *5. All right. Next question is number 11. Navigating H1B cap exempt and national interest waiver with new job offer. I'm graduating in May 24. Job offer in the state of California. Employer is willing to sponsor cap exempt H1B and they are filing for NIW. Yeah, good idea. During the initial year of OPT, is it permissible to work for a non-E-verified company? Yes, absolutely. It's when you do STEM OPT, you need an E-verified company. My employer intends to file H1B during my first year of OPT. Suppose my H1B is selected, but my OPT expires in May. Since I'm unable to apply for a STEM OPT extension because the company is not E-verified, what is the best course of action? Well, one course of action, I don't know if it is best, is if your OPT is expiring in May, make sure you get your H1B filed before that date. It's possible to do it. If you get it filed by that date, you get cap extension. So you can continue working till September 30th automatically, unless the H1B gets denied before that. Okay. Can I obtain an H1B cap exempt initially for continuous employment and later transfer to cap subject? Anytime you want to go to cap subject, you have to go through the lottery and win. Cap exempt, you don't go through the lottery. Last question, once the I-140 is approved through the NIW, is it mandatory to working for a cap exempt organization? Well, I-140 has nothing to do with cap exemption. I-140 is not connected to cap. H1B is. So you could get an H1B, let me rephrase that. You could get an I-140 approved through a cap exempt. So you've got your NIW, and as long as the NIW is worded properly, you could change to any employer, including an H1B cap employer. Your green card doesn't get affected, but your H1B does. So H1B, it matters whether it's cap or cap exempt. I-140, it does not matter. *5, if you have a follow-up question, press *5. Question number 12. H1B transfer after grace period. My question is about reactivation of H1B. In a scenario where I leave the job, use the 60-day grace period, return home for some time, later point while current H1B is still in valid time, get a new employer and reactivate, transfer my employer and return to USA. From a visa point, what all is required to execute this? You just need an H-1B approval from the new employer. Do I go through the lottery again? No. Do you go through the stamping? Well, if you don't have an old visa stamp, which is still valid when you return, you will need to get a new visa stamp. Okay, just 1 second. So you will not need a visa stamp if you already have an existing valid stamp. Otherwise, you will need to get a visa stamp done. Okay. *5. If you have a follow-up question, press *5. All right. Next question is H-1B cap exempt versus cap based transfer, concurrent work and employer notification. So he has some questions about H-1B cap exempt and H-1B cap based visas. Case 1. Person X cap exempt. When this person gets picked into the lottery, at one point will her current employer be notified? The current employer does not get notified. Well, if there are multiple employers applied for the same lottery the same year, my understanding is they'll all find out. But if you are already working for a cap-based employer, your lottery employer will not find out about the H-1B. Well, I don't know. This is complicated. I think both can find out. When this person gets picked into the lottery for H-1B cap, at what point her current employer be notified? Well, so if you're already working for a cap exempt employer and you won the lottery through another employer, would the cap exempt employer find out right away? No. They'll find out only when you do an extension transfer amendment. One of the three. If the person decides to work concurrently with another for-profit employer, does he have to ask current employer for permission? I think they should. You might have contracts. There might be even law that prohibits that. Otherwise, they don't find out. Oh boy, this is a lot of questions. Please try to keep your questions short, guys. I don't have time to read everything. There's like 5 more questions after that. Okay, you should ask permission. 3, move to a new employer on October 1st with H-1B cap-based visa. Can you still continue to work for the old employer concurrently? Yes, you can. Can I use the same H-1B cap-based visa to work for both new and old employer? Yes, you can. Any traveling restrictions from March to October when you are working for cap exempt to cap-based transfer? Cap exempt to cap-based transfer. Talk to your lawyers. This is getting too complicated for me to sort out here. Yeah. So normally during transfers you can travel. Case 2, person Y, visa status OPT, picked for the lottery with start date October 1st. At what point is this person allowed to change roles? H-1B transfer after the start date? No, you have to file an H-1B amendment. And you can do that at any time, even while the first case is still pending. Okay, as long as you're not a lottery case. So after lottery, sometimes it happens. I've applied for some guys, let's say, transfer over to a new location. And while the first case is pending, another location change becomes necessary. I can actually do an amendment while the first one is still pending. Okay. *5. If you have a follow-up question, press *5. Okay. New Jersey. New Jersey, go ahead. I can hear you.
Sir, if we transfer the H-1B from employer A to employer B,
okay,
when employer is getting notification that I have initiated the transfer process?
Okay. So when you transfer your H-1B from employer A to B, A does not get notified. Only B gets notified because it's their case.
Right.
Okay.
And second additional question on the same case, that if my employer A, I'm working at the New Jersey and I started working in the Massachusetts, so they filed an amendment for the job relocation. And while amendment is filed and process going on, if I transfer from A to B, is it still possible to get the transfer, or should I wait for the once the transfer is finished?
So your question is, can we do a transfer while an amendment is pending? That's your question, right?
Right.
And the answer is yes, you can. Okay.
Thank you, sir.
Good luck. By the way, another question I get asked a lot is, do I get 60 days with each approval? And the answer is yes. The 60-day grace period is not just one-time deal. Okay. Question number 14. Travel with advance parole after 180 days. Job loss. Okay. My AOS is pending 180 days EB2. EAD is valid for 2 years. If I lose my job, can I travel out of the country? We just discussed that. Shouldn't travel out unless you have a job or a job offer for same or similar job. And if you are going to travel, I prefer you file supplement J. Okay. So don't travel if you're unemployed. I think it's a problem. Press star 5 if you have a follow-up question. Press star 5. Okay. Question number 15. L1A to day 1 CPT. Okay. Currently on L1A, looking for options to stay back. Is day 1 CPT? Yeah, I think day 1 CPT is okay. Only thing I recommend is make sure that it is a justified enhancement to your career, that you're not just randomly taking degrees. Can I move to day 1 CPT courses? Can I go to India and come back to join day 1 CPT? I think that's the problem, because if you have converted to F1 already, you'll have to get an F1 visa. Okay. And day 1 CPT people might have trouble getting a visa stamp. Not that there is anything illegal about the CPT. It's just that the government agencies don't like it when people try to use this as an excuse to get work authorization. Okay. Is there any other option where I can stay and work? Not unless you qualify for something like an O1 visa, O1A visa, which is like one of the top people in the country in your profession. Star 5, if you have a follow-up question, press star 5. All right, question number 16. OPT expired, laid off, STEM OPT pending, grace period, new job and teaching options. I'm on OPT, applied for STEM OPT, no approval yet. OPT EAD is expired, I'm laid off. My company told me that they can show that I'm on vacation for up to 1 month, but can't pay me. My last paycheck would come on the 7th. They said they could delay the paycheck. I don't think you should do that. I have 1 month remaining in my OPT grace period. Okay. If I get STEM OPT, it will be additional 2 months. Right. My doubts. When does the OPT grace period start? Is it after there is no grace period. Okay. This is not H1B. I don't think there is any grace period, automatic grace period after an OPT layoff. OPT rules are different. OPT says first year of OPT, you can get 90 days. Other 2 years, STEM OPT, you get 60 more days. Whatever days you have not used out of the 90 for the first year OPT, you can use for your STEM OPT. So, for example, let's say that you were in OPT first year and you use only 10 days. That means 80 days remaining. Then you got STEM OPT, which gives you 60 days. Now you have 140, 80 plus 60 days that you could be off work while you're on STEM OPT. I hope that makes sense. So there's no automatic 60-day grace period. Would the 2 month, so on OPT and STEM OPT, we only look at when you're actually working. Okay, can I start employment at a new company without the new AD? No, you cannot. You have to wait for it. If you're in the 180-day period, so if you applied for a STEM extension and then you have 180-day grace period to continue working, can you change companies? You'll have to double check with your DS. So I think there might be a way to do that. Okay. I did MS in CEN. I don't know what CEN is. Does anybody know what CEN is? CEN. Press star 5 if you know. Sorry, I have no. Oh, okay. C engineering, computer engineering. That must be it. Go ahead. Is it CEN? Computer engineering?
Yeah, computer
Okay.
engineering.
Thank you. I wasn't sure. Thanks. Okay. So yeah. So I did my MS in computer engineering. I'm on STEM OPT. I know that you need to be under guidance in STEM OPT. Can I take teaching job at a school or university? Well, if the university is going to supervise you and they are willing to file your 983, I don't see why not. They are just another employer. As long as they are e-verified, I think you can. Okay. Star 5. If you have a follow-up question, press star 5. All right. This is from area code 951. First one is 951, then 857. So California and Massachusetts. Let's see. California, go ahead, please. California.
Hi. I wrote this question. And the first question, actually, it's not, I mean, I used the wrong words, but it's not the grace period. I meant unemployed days. So.
Oh, yeah. So unemployment days will begin. You know, that's an interesting question. I don't remember if I have ever read this before. If I get paid, but I'm not.
It a lot, but I'm not getting a perfect answer for this.
Yeah, I don't.
It's a little bit difficult.
Did you speak with your DSO?
No, not yet.
Talk to your DSO. Ask them, I'm not working, but I'm getting paid. Is that a problem? Personally, I don't know what the answer is.
I'm not getting paid.
Oh, if you're not getting paid and you're first year OPT, right?
Yeah, and that too expired.
Okay. No. If you are in first year OPT not getting paid, that's okay as long as you're actually working. Okay. But if the first year OPT has expired, I mean, I don't know. Are you in 180-day grace period?
Yeah, I was. And but so I could technically work. I mean, I saw this on USCIS's website that I could work for 180 days, till I get the STEM OPT, but only for the current employer. I mean, again, this is not.
Yeah, I think there is a way to start working for another employer. You have to go through some shenanigans. It is complicated, but it can be done. Check with your DSO. There is a procedure for it. And the only complication is, and I'm kind of remembering what I found out about that. We had that situation a few years back. And I think what I found out was there's a practical difficulty. When USCIS looks at your EAD application for STEM OPT, and they are not able to find your name in the current payroll of the employer who helped you file, they can deny, saying you're not working for that employer because you have moved over to another e-verified employer. But if you can get the information to the USCIS and they have not yet decided your case, they should be able to approve it for the new employer. I think that's the rule. Okay? Make sense or no?
My doubt, like the first question was, when does the 60 days of the STEM OPT add on? Is it only after I get the card, or does it add on right now, or after the last paycheck, or like?
Okay, so when you're in 180-day period, now this is what I remember. I could be wrong. Your unemployment does not begin until your EAD is issued within those 180 days. Got it?
So even if I'm unemployed, the number of unemployed days do not count?
No, not during those 180 days, because you're still waiting for your EAD. I think so. Okay. Double check it.
Okay.
But this is what I remember. Again, these are just random memories that I don't remember exactly what I found out because I've looked at this before. And I thought that as long as you were in the 180-day grace period, you had the option to work but not the obligation to work. But once the EAD was issued, then your unemployment began.
Oh, okay.
That's what I thought.
Okay.
But double check it, please. Don't take my word for it. How do you double check? Just contact
Okay.
your DSO. They should be able to find out.
Okay.
All right.
Okay. Okay. Thanks a lot, Rajiv.
You're welcome, Ji. Good luck. Good luck. Let's go to Massachusetts. Yeah, Massachusetts. Go ahead, please.
Yeah, hi. Thank you for your time, sir.
Yes, ma'am.
So my question is regarding the post-completion OPD as well. So the thing is, can my post-completion OPD start date be before my graduation date? Like I graduated on 20th December 23, and I requested for my OPD post-OPD start date to be on 8th January, but they approved it for 13th December.
Okay. You need to talk to your DSO. There is a 30, 60, 90-day rule, something like that. I think you can apply within 60 days before you graduate, within 90 days, something like that. And then the DSO has to make your DSO has to make a recommendation.
So the start.
Yeah, go ahead.
Okay. Yeah, but no, the thing is, they approved my EAD, but my graduation date was 20 December 2023. And the approved start date that they gave me for my EAD was 13th December 2023.
Yeah, so you need to, like I said,
which is before my graduation.
Yeah, I think you need to talk with your DSO. I have heard of this before, and I think we count them as unemployment days. Okay. Now there's a recommendation.
We count them
as unemployment days.
Unemployment.
Yeah. There is some recommendation by the DSO I have seen where they say, okay, our school policy will allow you to start interning, like for a college professor during that time, and that's okay. So let's say that you have 18 days of period where you are still in school, but you have to do your OPT because the EAD is already approved. You could actually intern for a professor. So they will allow that. Double check with your DSO. This is about school policy now. This is not about any USCIS laws. What happens is schools have these policies that when you are in school full time, you can't even do internships without asking them.
Yeah.
Okay. So check with your DSO, see what they suggest in your situation.
Okay. So this is not a USCIS error, right?
No, I don't think so. I think they approve it. If they approved it within the time period which is recommended, the 30-day time period recommended by the DSO, then it's not an error. See, so what the DSO does is they make a recommendation and you have to file your EAD within 30 days of that, right?
Yeah.
Okay. And if you did all that and the DSO has calculated the time correctly, it's not an error on the part of the USCIS.
Okay. So I'll need to talk to the DSO.
हाँ, DSO से बात करो आप. हाँ, पता करो उनसे. Yeah, ask them.
हाँ, ठीक है.
Okay.
Yeah.
Good luck.
Thank you so much.
You're welcome.
Yeah.
Okay. So now we are on question number 17. H1B transfer after layoff India. Old stamp valid, no I-140 employer questions. Arre Baba. I got laid off while in India. Found a new employer who's willing to do an H1B transfer. I don't have an I-140 approval, but my H1B stamp is valid till September of this year, 24. My old employer has already withdrawn my H1B. Does that mean I'm out of H1B status? Do I need a new stamping? So if you return to USA with a new H1B approval before September 24, you do not need a new stamping. Okay. Number 2, when a new employer files for LCA, where should I post the LCA? I live in India currently. LCA is posted where you actually work. So if you're going to work from home, when you return to USA, you'll have to do an H1B amendment. If you are going to work from the office or within 50 miles from the office, just do an H1B for the office. Yeah, if your job will be remote, you need to have a work address. So either rent a place and do the LCA posting there, or find a job within 50 miles of your office. Since I'm in India, the employer has to do consular processing. That is correct. But you can return with the consular processing approved H-1B and your old visa stamp if you come before September. Okay. Star 5. If you have a follow-up question, press star 5. Okay. Last question is L1A extension approved, stamping pending, applying for visitor visa. I had my L1 extension approved, stamping is pending. I want to apply for a visitor visa. Can I submit DS-160 for both? I don't know. But they probably will give you only one visa. Let me rephrase that. If your L1A gets approved and you apply for a tourist visa, they'll probably cancel your L1. You can always reapply. But technically, they should be cancelling all the existing stamp before issuing you a new visa. Will they do it? I don't know. Would getting a B2 visa impact my L1? Like I said, if you already have a visa approved, they'll probably cancel it. You can always reapply. So this is complicated and not complicated. Star 5. If you have a follow-up question, press star 5. Okay, I have 4 minutes. That means I can answer one more question. Press star 5 if you have a question that I haven't answered. Press star 5. Okay, good. I think we are done. All questions answered. I'll see you next week on LinkedIn. Always a pleasure to hang out with you guys. Take care. Bye-bye.